Hello, how are you? I hope you all are fine. Now let's discuss the topic of proclamation of state emergency, that is president's rule by the President of India under Article 356 of the Indian Constitution. This is the most controversial topic for the judiciary exams as well as for any law exam in India at present. You see, state emergency, that is president rule, has been imposed mostly in Punjab state, Bihar state and Uttar Pradesh state after the declaration of independence by the India against the British rule. So Uttar Pradesh, Bihar and Punjab are the three states in which president rule was imposed maximum times. In fact, in Punjab it was imposed for 7 times. So what are the grounds for imposition of president's rule or this constitutional emergency or state emergency under Article 356 of the Indian Constitution? The main and the foremost ground for the imposition of president's rule or state emergency is failure of the state according to the Constitution of India. Failure of the state machinery. The state is not working according to the constitutional provisions. There is genuine failure of constitutional machinery in that particular state. The state has failed the constitution. The state is not working according to the provisions given under the Indian Constitution. Especially under Article 365, the center gives certain directions to the state governments and the state government have to comply those directions given by the central government to the state government. But the state government does not comply with those directions. For example, the direction can be for the safeguard of the railway lines which are in that particular state. The direction may be to take care of the national highways which run through that particular state. The state is not taking care of that highways. The central government gives certain directions during emergency situations like COVID to take care of the people, or some financial regulations are imposed by the center on that state and the state is not complying with those financial regulations or rules. So all these can be certain directions. I am giving certain examples. There can be many more examples, and the state is not complying with the directions given by the center under Article 365 of the Indian Constitution. Then the central government can give advice to the President of India for the imposition of state emergency. Not only this, if the governor of the particular state thinks that the state is not working according to the constitutional machinery, it can give a particular report which should not be biased. By the way. The governor is the agent of the center, but he should be a neutral person. He should not be a committed person to the particular party at the center. So the governor can give a report to the President of India that according to his thinking, or according to him, the state government is not working according to the Indian Constitution. The state government is failing Indian Constitution, or the state government is not working according to the constitutional directions given under the Constitution, and there's a lot of chaos in the state government, in the state. There's a lot of corruption, or there's a lot of violence. So law and order situation is not good. Very grave law and order situation is there. People are resorting to riots, or there's complete constitutional breakdown in that particular state. You see, there can be many grounds. Or there is a tsunami there if it's a particular state in the coastal area of India, or there is some earthquake. Yeah, these can also be grounds of imposition of the president rule or state emergency. If there is earthquake, there is tsunami, or any other calamity by which the whole administration of the state has totally broken and people are feeling a lot of danger remaining in that state, lot of riots and lot of violence is there. People are breaking the law and order and the police is not able to control the people. That state police is unable to control the riots or violence which is perpetuated by the people or some particular group of the people throughout that state. Even the public buses, private buses, or the public property is been burnt by the people, by the rioters, and the state police is a mere spectator. It cannot control the riots or other situation. Then Obviously, there is social media reports also. So the president, through the report of the governor, or even through social media also, if he thinks that, obviously central cabinet will give certain advice to the president also, but it is the president who will take the final decision whether to impose the president's rule, that is state emergency on that particular state or not. It is the final decision given by the president of India. If the president of India thinks that really the state government is not working according to the Indian constitutional provisions, or the constitutional machinery in the state has totally failed, miserably failed, then the president can impose the president rule, and now the governor will take care of that state, and that state will work according to the directions given by the governor. It's not the CM or the cabinet. The CM or the cabinet, that is the executive of the state, will be dissolved, or it can be suspended. The state government will be suspended. Even the state legislative assembly can be suspended, or it can be dismissed. It can be suspended, or it can be revoked, whatever you can call, for that particular period of the state emergency, and the whole powers will be given to the governor, and governor will rule that state for that particular period of the state emergency, which can extend up to 3 years only. Obviously, 44th Amendment Act of 1978 says that once the state emergency is imposed, it can be extendable up till 1 year only. But maximum period for the extension of state emergency once it is imposed by the president is 3 years. But obviously, the same procedure has to be followed. The only difference is that the national emergency, once proclaimed by the president, has to be approved by the Parliament of India, that is Lok Sabha and Rajya Sabha, within 1 month. But in state emergency, that is president rule, the president, once he makes or he proclaims this president's rule or state emergency on that particular state, once he gives his proclamation, then after his proclamation, that emergency, that is president rule, has to be approved by the Lok Sabha and Rajya Sabha, not in 1 month but within 2 months. Yes, this is the difference between national emergency approval and state emergency approval. In national emergency, the emergency has to be approved within 1 month by the president, by the Parliament of India. But in case of the imposition of state emergency by the president, or the president rule by the president on the particular state, it has to be approved by the Parliament, that is Lok Sabha and Rajya Sabha, within 2 months of the imposition of that president rule or state emergency. Once it is approved by the Lok Sabha and Rajya Sabha within 2 months, then it can be extendable up till 6 months. Before 6 months, it can again be extendable to other 6 months, second 6 months. And if again the same situation remains there in the state, lot of violence, lot of mob violence, rioters, and the state is still not working according to the constitutional machinery, then it can be extended to another 6 months. This way it can be extended up to 3 years. This is the maximum period. But 44th Amendment says that once it is imposed, it should not be extendable more than 1 year. After all, it's a democratic country, and the state government should not be suspended for infinite time. It's a democratic country. We do election. We need elected representatives. We need running democracy. So if it is the emergency situation remains forever, then there is no need of elections there. It's not democracy. It's autocracy. It is totally autocracy. So this is the reason why the state emergency cannot be extendable beyond 3 years. So the very important and the main case law, landmark case law regarding state emergency is S.R. Bommai versus Union of India 1994. In this case, the Supreme Court said, obviously, why this case was there in news in 1994, S.R. Bommai versus Union of India, because before S.R. Bommai, this state emergency, that is president rule, was misused by the central government many times, especially in Punjab, Bihar and Uttar Pradesh. So a lot of writ petitions were filed in the Supreme Court, and finally Supreme Court in S.R. Bommai versus Union of India 1994 held that the state emergency should not be imposed haphazardly, without any reason, without any genuine reason. The state emergency cannot be imposed. There must be some genuine reason for that, and the genuine reason for that is the failure of the constitutional machinery in that particular state. There should be no other reason. No political considerations, no extraneous considerations should be there on the imposition of the state emergency on a particular state by the central government through president. Because usually what happened earlier, before S.R. Bommai case, what central government did, that if it sees that particular state has some government which is not aligned to its policies or its ideology. Usually in some states there must be some governments which are made by some other party which is not according to the which is not the party in the center. Its ideology or its thinking is totally different than the center. Then the center, to impose its own dikkats, it took the advantage of this provision and it imposed the state emergency on that particular state, just because there is ideological difference, or the party which was heading in that particular state, which was having a government in that particular state, it was not aligned to the ideology of the central government. So it was very much misused. This state emergency provision, that is Article 356, was very much misused by the central government. So finally in SR Bommai versus Union of India, it was held by the Supreme Court. No extraneous considerations, nothing sort of that should be used for the ground, as a ground for the this imposition of the state emergency. State emergency or the president rule can be imposed only on one genuine reason, that the state is not working according to the Indian constitution, or the constitutional machinery has failed in that particular state. No political reason should be the ground for that. Or obviously if the governor's report says that there is no party is able to claim the majority in the particular state, there is elections in the state, and there is a coalition government in the state, and various parties are there, and most of the MLAs they are belonging to different parties, but there is a coalition government, but they are not able to claim majority there. They are showing their whatever they are trying to say, that we are claiming majority, but actually in the floor test they failed the floor test in the particular assembly of that particular state. So if any of the parties are not able to form the government, they fail the floor test, that is not able to form the majority in a particular state assembly, then the president can inform this situation to the president. The governor can inform this situation to the president. The governor can make a report about this situation. There is no majority party in the particular state, no government can be formed, and nobody is able to claim to form a government. Nobody is coming forward to form a government because they are not having majority. They are not having 50% shares of votes. Then the president can proclaim president rule on that particular state. So this was in case of this president rule or state emergency. So I hope you like the lecture. Anybody who is interested in judiciary exams, especially Punjab judiciary, Haryana judiciary and Delhi judiciary, they can contact me. My contact number is 9646526942. I again repeat the number, 9646526942. So you are welcome. We can have offline classes, we can have online classes also. Thank you very much.